Hello, friends, and welcome to another exciting episode of Today with Tally. The mission and goal of this podcast is to bring an engaging conversation that will add value to the lives of everyday people. We will inspire, encourage, educate, and tell the stories of America's finest men and women in an effort to motivate you to live your life to its fullest potential. Be sure to follow us on social media and search Today with Tally. Be sure to subscribe, follow, and share the program as well. Ladies and gentlemen, your host of the evening, Mr. Brian Tally.
Welcome back to the Today with Tally podcast, where we add real life value to the lives of everyday people. Folks, it has never been easier to listen to this podcast. We are on YouTube, Spotify, Amazon Music, iHeartRadio, Twitter, Facebook, and About Face Radio. Simply search Today with Tally. And be sure to like, share, and subscribe to get every episode and stay up to date with the latest and greatest our guests in this show has to offer. Folks, I also wanted to let you know that we are brand new to Reefs Across America Radio. I know that's very hard for me to say, Reefs Across America Radio. We have just been picked up by them, and we have a podcast there that is going to be played every Wednesday night and Saturday night. On Wednesday night, it's 9 p.m. Eastern. And Saturday nights at 11 p.m. Eastern on Reefs Across America Radio. They can be found on the iHeart app, the Odyssey app, and on the TuneIn app. So I look forward to seeing everybody over there on Wednesday nights at 9 Eastern and Saturday nights at 11 p.m. Eastern. Now, folks, we have a very special guest joining us on today's program. But before I bring him in, I want to set this up a little bit. You guys have been seeing the commercials and all over the place, the Camp LeJeune water issue, the contamination that has taken place in Camp LeJeune, North Carolina for generations. Now, we are going to talk all things Camp LeJeune today. Now, the attorney that I'm going to have on the show is Ken King. He has practiced a law and has been an advocate now for the last 30 years in the Jacksonville, North Carolina region of Eastern North Carolina. Now, he practices workman's comp, personal injury, litigation, and wrongful death. But right now, he is now on a mission, and he's dedicated to help those who served in Camp LeJeune from the contaminated water. And folks, this is a time-sensitive thing, and that's why we have Attorney Ken joining us today. There are so many diseases and illnesses that are associated with the Camp LeJeune water contamination. And with that, we are honored to be joined by Ken King. He is the principal attorney from the King Law Firm. How are you, sir?
I'm fine. Thanks, Brian. Thanks for having me on.
Hey, the pleasure is all mine, sir. I'm honored to have you on the show today. You know, our show does reach a lot of veterans, as well as veteran supporters. The veteran supporters may have had family that served in Camp LeJeune, as Marines early on in their life, as you did as a child, as your father was in the Marine Corps as well. So we want to try to get all this information relayed out to the folks that are listening to this, so we can get the good knowledge and the information in their hands so they can act appropriately, as this is time sensitive to file claims for illnesses and diseases that they may have picked up from this contamination from Camp LeJeune, North Carolina. So we do appreciate you joining us today.
Thanks. Glad to be here.
So I want to know how this all originated. Now, before we dive in here, you are a former U.S. Marine, JAG officer. And you first moved to Camp LeJeune in 1973 with your father. What was it like growing up in Camp LeJeune?
Well, it's funny you asked that question, Brian, and I've shared this with a lot of attorneys around the country. Back in the day, when we first moved to Camp LeJeune in the early 70s, and of course, I continued to reside here until I went off to college in 1979. The Marine Corps base, and particularly Camp LeJeune, was a sanctuary for Marine families. And by sanctuary, I mean that's a place where we were comfortable. The Marine Corps did an outstanding job of providing not only for the families, but for the dependents. And that included everything from recreational activities to medical care, which, has changed somewhat over time. So we enjoyed it, and it played a big role in our lives. And one of the reasons I think that is important is sometimes it gets lost on people that are hearing about the Camp LeJeune water crisis, thinking that if they weren't on active duty or didn't live aboard the base, that they don't have a claim. When the reality is we represent a lot of people who actually lived out in town that were dependents, but were on the base on a regular occasion for the commissary, the PX, the Naval Hospital, the base stables, and all the other activities that were offered.
I have the dates here from the Camp LeJeune contamination that they came up with. August 1st of 1953 to December 31st of 1987. So that goes for dependents, anybody that was on that base, as well as active duty Marines, their spouses, everybody else like that. What happened prior, right around at that 1953 mark? What caused this water contamination in Camp LeJeune?
Well, originally, and I know, from your prior Marine Corps experience, the role the dry cleaners played in military uniforms and having starched uniforms available for wear on a regular basis. So there was a large dry cleaners known as ABC Dry Cleaners. It was located right outside of Tarawa Terrace. They were one of the primary polluters early on in the process. That facility opened sometime in the late 40s, early 50s, and there was almost an immediate issue with them contaminating the groundwater with the perchloroethylene that was utilized in that dry cleaning process. So as that went on over the years, it was just a steady sort of drip, drip, drip of chemicals into the groundwater. And of course, then the wells aboard the base that were utilized to pull that groundwater, which was served to the Marines and their families, became more and more contaminated over time. So what we see in the groundwater contamination studies is that it got progressively worse through the years from the early 50s up until the late 70s and even early 80s before they finally actually shut down those wells. Initially, the thought was that it was the dry cleaners that was causing the problem. Unfortunately, later on, we learned that the Marine Corps themselves were largely responsible because they had deteriorating underground storage tanks that were filled with fuel. I've heard stories from Marines about disclosure of bulk fuel and excess fuel, and it just went on for years. And hydrologists can better explain it than I can, but the reality was all of these chemicals were seeping into the groundwater, and then ultimately when the wells were put in place and the water was drawn up, it was then distributed throughout the base to basically all of the facilities, some worse than others, but really throughout Camp LeJeune.
Now, we all know, being on a federal base, they're very, they're always testing this, groundwater. I know when I worked hazmat in Camp Pendleton, that was a big thing to always, go around, they're always checking air quality. They're always checking water. They're always checking this. And it could be now because of this incident that happened. But typically the federal government's going to be really on top of testing the water and having these protocols in place for the folks that are actively serving on the base. Did this never happen, or did it happen and they just kind of covered it up?
It was unfortunately kind of a combination, and it's still not clear to this day who knew what, when, and how aware they were of how serious the problem was. I mean, they knew there were some chemicals present, but as far as the carcinogenic level of those chemicals, and I'm sure you probably know, there's a latency period where people can ingest these chemicals, and it may be years and years and years before it manifests itself in the form of various diseases. There was an issue with young military wives, dependents, and miscarriages and other issues, but it was never really associated with the water until many years later when they realized that some of these chemicals and the impact it had on an unborn child. So it's not clear. We do know by the late 70s, early 80s, they knew they had a problem. They weren't really sure what it was going to take to address that problem, but they did start taking steps to close the wells in the 85, time frame. By then, the water was highly contaminated. There had been some government studies which confirmed it, and the Marine Corps knew they had a problem that had to be addressed.
So once they found out about the problem, what were the steps that they took to start to fix the problem?
They actually had to close wells and generate new water supply sources. So they began shutting the wells down in the early 80s. And it wasn't until 87 that they were at a point where they felt like they had provided alternate water sources that were not contaminated. The contamination level was not the same throughout the base. One of the key issues, for example, New River Air Station, Courthouse Bay, some of the other wells weren't contaminated. But the problem with earlier on was they were blending the water. So as there was water shortages in one area of the base, they would divert water from Hadnot Point or Tarawa Terrace or Holcomb Boulevard. They would divert that water into other areas of the base. And there really did not appear to be accurate records of how often that happened or how much water was actually diverted. But the Camp LeJeune Justice Act says 30 days or more at Camp LeJeune. So at this point, it's unclear, what position the government's going to take for those Marines, for example, and their dependents that were stationed at New River Air Station, where the water was not contaminated from the source, but there was the blended water that went on, for years, where that contaminated water would have been mixed in with the other water.
Now, did this ever require excavation of actually putting in new services and new water main line, or was this all just done with gate valves and just kind of just disconnecting one line and then just kind of tapping into the new well?
Just new sources of water. Now, since then, they've obviously taken a lot of that housing down. They've done, one thing right now that we're all waiting on anxiously is the ATSDR is in the process of releasing another study in 2023. One of the issues is vapor intrusion. And for anyone who's spent any time at Camp LeJeune knows that we're a very hot, humid environment, throughout all the summer months. And what they have learned through additional studies is that even if you didn't actually consume the water, bathe in the water, swim in the water, that just the vapor that came out of the ground, in the heat of the summer and other times throughout the year, that was almost as toxic as actually having ingested the water and bathed in it and utilized it for, activities of daily living.
So that just doesn't make any sense to me, how they can just use the same pipe that was already completely contaminated. What did they do? Did they run anything through the pipe to try to clean it out and kind of disinfect what was in there before they put the new and fresh water in?
Brian, I honestly don't know the answer to that question. I know they took steps that satisfied the EPA and other agencies that were involved to make sure that it, eventually that contaminated, dangerous water was eliminated, from the standpoint of exposing the military members and their families to the water.
So who came up with these dates tonight? I understand the 1953 date from the late 40s from the ABC dry cleaners when that all started. That was the first sign that there was something wrong, and then all of a sudden the hazardous materials of the base started to seep through, and then we ended up having a bigger problem on our plate than what we had originally thought. But going to December 31st of 1987, who said that's the final date there that they're taking claims for?
The legislation that was passed. And, when the PACT Act was signed into law August 10th of 2022, they included a provision within that, which is Section 804, which is actually the Camp LeJeune Justice Act. And those dates were arrived upon or agreed upon as that legislation was being drafted based upon that ATSDR report and other information that was available that sort of established the time period when the water was contaminated to the point that it could have the negative impact on individuals that consumed it and utilized it during that time frame. So those dates really just mirror the statute itself, which is all the government has accepted responsibility for. So we do still receive calls from people who were here after that date. No one really knows at this point, other than the law only allowed claims to be brought on behalf of people who had 30 days or more of exposure between those dates at Camp. Mm-hmm. They don't have to be consecutive dates. You don't have to have lived aboard the base or have been active duty. You just have to be able to establish that you have 30 days or more of exposure to the water. So there's a lot of pending issues that'll have to be addressed as this litigation unfolds. When you talk about a day of exposure, obviously, if you lived in base housing and you utilize the water for all of your activities of daily living, then clearly you were exposed. If you visited the Naval Hospital for a medical appointment or examination, our position is that's a day of exposure.
Mm-hmm. Now, I lived in French Creek from late '95 all the way through 1996 until I went, until I PCS to Okinawa in '97. Now, what did French Creek look like? Was there certain parts of the bases that were far greater when it came to the actual pollutants itself, or and then some parts of the bases that didn't really have a lot of the contaminants, in the water?
That's correct. So what happened is Hadnot Point, the industrial area, Tarawa Terrace, Berkeley Manor, really what I refer to as main side, I think what you would refer to as main side.
Yeah.
There was a lot more exposure. The water was much more highly contaminated than, for example, I'm sure you remember Onslow Beach. They had a well. Courthouse Bay had a separate water source. New River Air Station had a separate water source. Those were not nearly as contaminated. But again, from the lawyer's perspective, the government was blending the water. So if you took highly toxic water and even if you mixed it with fresh water, there still was exposure far beyond the accepted, minimum exposure. And so the risk was clearly there. The statute says Camp LeJeune. The statute makes no reference to different areas of the base. It just says 30 days or more at Camp LeJeune.
Folks, we are being joined by Ken King. He is an attorney who is really taken on this Camp LeJeune water contamination crisis, if you will. He's taken everybody who was serving on Camp LeJeune or lived on Camp LeJeune as a dependent from August 1st of 1953 to December 1st of 1987. You could be eligible for benefits and or compensation due to the contamination in the water in Camp LeJeune. Now, you had mentioned the PACT Act, Section 804 that they put in. Was that the big omnibus bill that they passed toward the end of the year?
Well, the PACT Act, provided additional benefits for veterans that were exposed in Iraq and Afghanistan and toxic burn pits, and it's voluminous. It expanded the VA medical care and what's going to be provided to veterans. It was a wonderful bill in itself. But as a part of that, there's just one section, and it's a very short section. It's Section 804, which is titled the Camp LeJeune Justice Act. And that is actually the portion of the PACT Act which gave persons that were injured the right to bring these claims against the federal government, which is very unusual in itself for a number of reasons. North Carolina, what had happened in years past, these claims had great difficulty and were ultimately dismissed by the federal courts because of North Carolina's 10-year statute of repose, which prevented these claims from being brought because the harm occurred in all these cases where there was latency or you became aware of the harm more than 10 years after the act or the exposure. So it did away with the statute of repose, which allowed all of these claims to be brought, but it's only for that 2-year time period. So the claim has to actually be filed by August 10th of 2024, or as the law presently stands, you'd be forever barred from bringing a claim.
So this is why we are being bombarded with a bunch of attorneys with all of these Camp LeJeune, contaminated water commercials because of the time sensitivity to this by needing to have your claim in and filed by August 10th of 2024, correct?
That is correct. And what it's done, this is the first time ever, and being a former Marine, and although a lot of Marines don't know the name, it's referred to as the Ferries Doctrine. Mm-hmm. But it's been the law of the land here forever, where active duty military personnel, regardless of their branch of service, cannot bring a claim against the government for harm that they suffered while on active duty. This Camp LeJeune Justice Act is the first time in the history of our country that our government has told active duty military personnel that were harmed or harmed at the time they were on active duty, that they have a right to bring a claim directly against the federal government for that harm. So I currently represent a lot of former Marines, retired Marines, and Marines that served even relatively short periods of time as a reservist at LeJeune that now have one of these horrible diseases that are being afforded this right to bring that claim against the government directly. So this is the first time in the history that has happened. So it's sort of a once in a lifetime opportunity for them to receive some justice, by having a chance to bring a claim.
What types of illnesses and diseases have you specifically seen associated with this contaminated water?
So when you look at the diseases, there's a myriad of conditions that the lawyers ultimately believe the science will support being connected to substantial exposure to that toxic water at Camp LeJeune. But right now, and there's a little bit of confusion because the VA, the Veterans Administration, because they have seen so many claims filed, have been able to conclude that certain conditions are what they refer to as presumptive conditions for the purposes of VA disability benefits or for VA benefits, which is different than what the Department of the Navy and ultimately the Department of Justice is viewing as what quote unquote presumptive conditions. We still believe we're going to have to prove our cases as we pursue the Camp LeJeune Justice Act cases, whereas the VA has identified a list of conditions that they have found to be presumptive, meaning if you were on active duty during the relevant time period at LeJeune and you've got a medical diagnosis of certain conditions, you're entitled to VA benefits based upon that. The ones that are currently, and we think that this list will grow: adult leukemia, aplastic anemia, bladder cancer, kidney cancer, liver cancer, multiple myeloma, non-Hodgkin's lymphoma, Parkinson's disease. And then there's a myriad of other conditions: esophageal cancer, pancreatic cancer, lung cancer, brain cancer, that we believe the science will support those conditions being related. What we have told people is we'll be glad to review the medical, review the exposure. If they have the exposure and they have a medical diagnosis and all, there's a good chance that ultimately we'll be able to connect that condition to that exposure just because of the highly toxic nature of the chemicals that were in the water there at LeJeune or here at LeJeune.
Have you gotten any feedback on what happened post December 31st of 1987? Have you gotten anybody showing up with, with any of those illnesses and diseases that can relate directly to those specific dates of 53 to 87, but that on 87 say that somebody was there in 1992 and they're posing the same exact, diseases that they have called out? Are they allowed to submit?
Well, they can submit, but the way the law is currently written, they would ultimately be denied. Mm-hmm. So unless there's some new evidence, this statute is very short and concise, but it's also very clear. If you can't show 30 days or more of exposure to the water at LeJeune between those 1953 and 1987, then in theory, your claim or your case would be dismissed. Now, we believe and are hopeful that these additional studies that are coming forward, for example, vapor intrusion, they weren't able to remove all of these chemicals from the groundwater. Okay. And so we believe that there'll be some evidence coming forward over time. But now, whether or not that law will ever change to allow for those people to receive any compensation, we don't know at this stage. At this point, and when you raise that issue, one other thing to think about is someone such as myself. So I had substantial exposure really from 1973 until 1990. Well, at present, I don't have any known conditions, as you say there, but for the grace of God, go I. And so the question is, what if August 10 of 2024 passes and then 2 or 3 years later, people that had substantial exposure develop one of these conditions? So right now, there's no provisions for medical monitoring. It really doesn't address what's going to happen in those cases where people's conditions don't show until beyond that date. So that's one area that's still sort of open for consideration.
You know, we all.
I mean, from our perspective, the way the law is written, those people do not have a claim.
And it's my opinion as well that when a lot of these things do happen, a lot of the times bases cover stuff up. You know, I know people, you know, from Fort Hood here that have been having so many problems with other stuff, and the bases kind of they just cover stuff up, cover stuff up, cover stuff up. So when it comes to accountability and justice, are you there on the front lines as an advocate, working literally in the same town that you grew up in Jacksonville, North Carolina, the home of Camp LeJeune, North Carolina? Are you on the front lines there trying to hold the base and all the other JAGs and all of the other things that are coming down range, you know, accountable so there can be some sort of oversight here?
I mean, we're doing what we can from here. It was through great effort on a lot of people that went on for many years before they were finally able to have this legislation passed. Without this law, there really was nothing anyone could do in terms of seeing that these people receive compensation, you know, for the harms that they've suffered as a result of being exposed to that toxic water.
Mm-hmm. And, you know, when it takes years to, you know, for it to manifest until you find out if you got a problem, like almost like asbestos, right?
Absolutely.
You know, like, yeah, you know, I was exposed 30 years ago, but now I've got mesothelioma, you know, and now you've got all these mesothelioma commercials on there from stuff that happened 30, 40, 50 years ago, no different than this Camp LeJeune contaminated water. Now, unfortunately, this has taken 40 to 70 years, anywhere in between there, for this to come to light, for this to actually come to justice now for the first time legally through legislation, through the PACT Act. What are you seeing coming through the pipe here? Are you seeing a lot of these claims being granted and approved, or are you seeing a lot of denials?
At this point, there have not been any denials. There have not been any claims granted. There has been $0 offered or paid. And I think that's important because some of the lawyer advertising that is out there that I've been made aware of and I've actually seen, you know, indicates there's a check in the mail or checks have been received or the money's waiting for you to file and collect the money. At this stage, and this called, I think, everyone, including the Department of Navy, Department of Justice, our courts here in the Eastern District of North Carolina, a little off guard when it passed, from the standpoint that they're faced with literally thousands of these claims that they have to process and deal with. So the stage that we're at right now is we are filing the Camp LeJeune Justice Act claim form, which is sort of a bare bones form that puts the Navy on notice that an individual has a claim based upon the exposure and the diagnosis. The Navy's going through a process of what they refer to as perfection, which means they're going to take that claim form and they're going to verify that this individual exists and that they were at LeJeune or that they're aware of this particular claim. And then at that point, they're asking the attorneys to provide them with what they refer to as substantiation. And that could be a process that could take up to 90 days. That's when we would submit the DD 214, the SF 180, the service record book, whatever military records that we had available to us, the medical records showing the diagnosis. And then, of course, every one of these claims, Brian, is different, meaning they're individual claims. So an individual that was diagnosed with liver cancer in their 50s claim may be more valuable than one, for example, who was 70 or 80. If they were still working and gainfully employed at the time of the diagnosis and they lost their employment as a result of that, that would affect the value of their claim. So during that substantiation phase, we're going to be doing what we as trial lawyers do all the time, is presenting our case to the Navy and making a demand for an amount of money to settle or resolve the claim. The Navy has indicated there will be some negotiations, some discussions. They may request additional documentation or substantiation, but at some point the claim would either settle or and resolve, or the Navy will say, we can't meet your settlement demand, and they would deny the claim. At the time they deny the claim, you then have the right to file a civil lawsuit in federal court here in the Eastern District of North Carolina, wherein you're actually suing the federal government, and a jury would determine how much money you were entitled to receive.
Now, this is all individual claims. There's nothing class action about this, correct?
There is no class action. It's when you hear the term mass tort, it's only a mass tort from the standpoint that so many people were injured in the same manner. But every one of these cases is going to be handled individually. This is not like dealing with a Fortune 500 company where you have a large group of people that were all injured in the same or similar way, and there's a lump sum settlement that then is divided, amongst all of the plaintiffs. These are each individual cases, and they have to be worked that way and developed that way. If you don't settle with the Navy at the admin claim stage and you file a lawsuit in federal court, you're going to have to prove exposure. So for example, if you're a dependent and you lived out in town and your only exposure was however often you frequented the base over a period of time, we're going to have to be able to put on evidence that you were exposed. And so it depends. The exposure is going to be different. The condition that you're diagnosed with, we're going to have medical experts that are going to tie that condition to exposure to the toxic water. But in different wells had higher levels of different chemicals. So it can be somewhat complex litigation once you get to that stage or having to file in federal court.
Have you been in front of a judge yet and argued somebody's case yet when it comes to these claims?
Actually, no one has. No one's been in front of a judge, but April 5th, this Wednesday, they're going to have the first hearing. It's in Raleigh, North Carolina, in front of Judge Deaver, who's a federal judge, but it's going to be to address housekeeping in terms of how are we going to process and manage these claims. We have 4 judges in the Eastern District of North Carolina. At present, these cases are not even consolidated in front of one judge. So right now, each one of those judges may have their own separate docket of these Camp LeJeune Justice Act cases. The lawyers are hopeful that in working with the Department of Justice and working with the federal court system, that we'll come up with a system that will make processing this large volume of cases go smoother and avoid inconsistent decisions between different judges, and try to come up with some uniform standards that we can apply to each of these cases to make them go forward, in large part so these people that have been waiting for years and years can receive the compensation that they deserve.
Now, the PACT Act from last year, Section 804, as you like to refer to as the Camp LeJeune Justice Act. Of course, there had to have been a lot of background research on this between the Government Accountability Office and what it's going to cost, these estimates of perhaps how many claims they may get and what these claims may amount to. Did the federal government have a number that has been set aside that they have budgeted, say, $1 billion, $2 billion, $3 billion? Has there been a number released that they are going to cap at?
There has not been a number released. These are not appropriated funds. This act basically created this cause of action against the federal government for compensation. So I don't believe that the Congressional Budget Office had set upon a specific projection in terms of what this would cost. And in large part, I've heard all sorts of numbers. Early on, they said as many as 500,000 people, may have claims. I think the number is substantially less than that. So it was difficult to put a number on it. And also not only from the standpoint of the volume or the sheer number of claims versus the value of these claims. So that's one of the struggles that's sort of ongoing without having a jury actually hear some of these cases and the horrible things that the Marines and their dependents and Navy personnel as well, all the personnel that were exposed. We really don't have a sense of how a jury would view these claims and what sort of value that they would assign. We know it'll be substantial, but we don't have specific, numbers at this stage.
Do you ever really believe that this will ever really reach a jury? I mean, because typically a lot of these are, litigated way prior to anybody ever seeing a federal judge. What do you see? Like, what's your personal, or I guess you can give both, your personal and professional opinion on how this will actually look like once they start to approve the process of these claims?
I think there will be trials. I mean, I'm hopeful that within the next 6 months that we'll have some of these cases going to trial. in front of a jury and having a jury determine the value of some of these cases. I mean, the stories are just terrific in terms of what families have gone through. One of the things we as lawyers have talked about is when you talk about an auto accident and back surgeries and the various things that we deal with on a regular basis, cancer and just the term cancer has its own horrible significance. But when you hear these stories of the chemo and the radiation and the things that people have gone through, waking up every day, wondering whether or not the cancer will return and the regular appointments, they're just devastating stories. And we think that a jury, when we do get one of these cases in front of a jury, that the jury is going to be incensed and that we're going to see very significant awards. And the reason that's important is because it will require the government to take notice that these people are entitled to substantial compensation for what they've gone through.
Sure. Of course, seeing a jury, you're going to get, folks that are going to be, empathetic, if you will, to what they're seeing and hearing. And being injured due to no fault of your own, that's a tough pill to swallow. I'm one of those guys too that had some egregious medical malpractice happen to me that destroyed the innards of my body. But drinking water when you're stationed on a U.S. military installation, fighting for your country, you would never think that something like that would come into fruition, but it did. Now, my only issue with this is that it's taken 40 to 70 years to get any sort of accountability and justice here. And with the amount of tens of thousands, if not hundreds of thousands of people that have been affected by this, and you start talking about, we're going to do one court case at a time, this is going to take decades to figure out. I mean, I don't really see where the justice is going to come swift and quickly here.
I think you're right, and you make a very good point. Actually, I was at one seminar where someone mentioned the idea that, everybody present would be dead and gone before all these cases could ever be tried to a verdict in front of a jury. But the idea is we're all sort of in this nebulous zone where we're trying to say, well, what is this case worth? And we've roundtabled it. We've discussed it. I mean, what's a reasonable amount of money for someone? I can tell you that the clients, the people that I represent, some of them would be grateful for an amount of money that would change what life they have left, that they would have access to now, that they could do something for their children or grandchildren and have a better life in the time they have remaining. And then I have others who want their day in court. And they want to have their opportunity to tell their story to a jury and let a jury decide what they're entitled to receive. I think in the next 6 months to a year, some of that will flesh itself out. And I think a lot of the claims hopefully will resolve for reasonable sums of money. But at the same time, some of the cases will just have to be tried. Now, how many will have to be tried and how many verdicts will have to be entered before the bulk of those claims resolve, no one knows at this point.
Yeah, and I do definitely understand wanting your day in court, and wanting to be heard and wanting to be seen and to get real and raw and graphic on what these illnesses and diseases has brought forth to these U.S. men and women, these service members and their family, the dependents, the civilians that help run that base with MWR and the Chow Hall and all these other areas of service. As we all know, that base is a mini city. You don't really need to leave. You got everything there, but there's a lot of people that keep that operational. And there's a lot of people that got sick. What if, the person that you said, hey, I want to see a judge. I want my day in court. I don't care what it's going to take. What if that person passes before that opportunity arises? Can they have their next of kin go in there and operate on their behalf?
Absolutely. And one of the things that is, to answer that question, yes, we would literally substitute a personal administrator for the deceased person, and the case would continue. Obviously, it may not be as impactful if the injured party's not there and able to testify about what they've been through and how it affected their lives, but they would still have what's referred to as a wrongful death claim. One of the other unusual things about this act that I'm glad you asked that question is normally there's a 2-year statute of limitations on a wrongful death claim in North Carolina. That has been waived. So I actually represent people whose loved ones passed away 10, 15, 20, 25 years ago from kidney cancer, liver cancer, any of these horrible diseases, that we're in the process of opening wrongful death estates here in Onslow County, which is Jacksonville, North Carolina, and pursuing those claims on behalf of the family members that are still alive. So even though the loved one, may have passed away in 1985, during this 2-year window, they have a right to bring a claim, based upon their wrongful death, which is very unusual. So we have quite a few of those too that we're actively pursuing, where the loved ones were lost some time ago.
So at least the state of North Carolina is indeed working in the best interest here of the victims of this Camp LeJeune water crisis.
Now they are, from the standpoint that, Jacksonville has sort of become ground zero for all of this. And so if people passed away, it gets kind of complicated from an estate standpoint. All of the questions haven't been answered. But right now, Onslow County is opening these estates for everyone who died out of state or died here in the Onslow County area. And as you know, from having been in the Marine Corps, and you mentioned it earlier, the base supports the town of Jacksonville as well. So almost in some way, almost every family seems to have been touched. I mean, and at some point they had a loved one or a family member, someone that actually worked aboard the base for years. I represent people that distributed beer, for example, and food goods that were on and off the base on a regular basis over the years. So it's affected a broad range of people.
Oh yeah, I mean, absolutely. Like I said, you got people that work at the hospital that are civilians. They got people working in the PX that are all civilians. They work there for 10, 15, 20 years. A lot of people from back east, they keep the same job forever. They retire where they start. And again, those people are going to be just as, polluted, if you will, as the Marine, or the Marine dependent. They are going to have all that level of contamination as well. And that's why it's really open to everybody here, not just active duty Marines and their dependents, also civilians alike. Now, we always see, when these legislative bills pass, when the federal government starts to release funds, for an example, like the Camp LeJeune water contamination crisis here that they're giving you guys a couple of years to get squared away. We have every attorney in the country jumping on this. Everybody is seeing blood in the water, if you will, and they're all attacking this. What separates your law firm from all of the other law firms out there that are jumping on this very aggressively with tons of radio ads and TV sponsors? I mean, just coming at you it's gotten so crazy. They have memes about the Camp LeJeune water crisis, all over, Facebook and stuff, because it's everywhere you go. It's everywhere you see. What separates you from everybody else in this game, Ken?
I think first and foremost, what separates me is my time, not only as a military dependent, as a Marine dependent, living here in Jacksonville, North Carolina, practicing law aboard the base, as a captain in the United States Marine Corps, JAG Corps. So I'm very familiar with the workings, the base, the facilities. And then from an exposure standpoint, I know what it was like, and I know how the exposure took place. And then more importantly, our principal office is here in Jacksonville, North Carolina, which is located in the Eastern District of North Carolina. And it's up in the air at this point a little bit, but you have to have a North Carolina attorney involved in your case in order to file suit in the Eastern District of North Carolina. We have 5 attorneys in the firm that are all admitted in the Eastern District of North Carolina. So when and if the time comes that you need to file a lawsuit, we're in a position to do so. And then, of course, we have offices here, and we're just sort of on the ground in a day-to-day basis. I mean, there are a lot of competent attorneys that are involved in these cases from around the country. But at the end of the day, they're not going to be transferred. And you mentioned earlier, class actions or mass torts. And often they'll have what they refer to as multi-district litigation. And they may calendar all the cases in one area within the country to hear them all. That's not going to happen in this situation. These cases are going to be handled right here in the Eastern District of North Carolina where we've been for 30 years. We're very familiar with all of those court processes, and we're just in a great position to bring these claims, on behalf of not only, as you mentioned earlier, active duty, but dependents and others as well.
Yeah, and I've done my fair deal of research on you, and I really couldn't think of a better firm to take on these cases. Again, being right there, boots on the ground. You've worked on the inside, you've worked on the outside, if you will. You have a team, a fairly large team. By going to your website, you can definitely see everything that you guys do for the state of North Carolina. But you guys can go check them out for yourself. It's kinglawfirm.com, kinglawfirm.com. And really, at the end of the day, guys, this attorney, Ken, is actively pursuing claims on behalf of former Marines, their dependents, civilian employees, and everybody else who may have been exposed to the water at Camp LeJeune. These are time-sensitive claims. If you served on this base or worked on this base in any capacity for at least 30 days, they don't need to be consecutive. They can just be a total of 30 days between the dates of August 1st of 1953 and December 1st of 1987. You may be eligible for compensation. And you can't find out unless you contact somebody like Ken over at his law firm, the King Law Firm, that is based in Jacksonville, North Carolina. Now, with that being said, is there anything else that you would like to talk about regards to Camp LeJeune, or what else people may need to hear? Or
I think the only other thing I would mention that I didn't mention earlier. So when this process started back in the summer, myself and two other attorneys in the firm became certified VA disability representatives. And I've learned a lot about the Veterans Administration and the VA disability benefits that are available to them since this all started. We really just never had the time to get involved, but I'm working with an attorney whose sole practice is VA disability benefits. And I would just encourage any of your listeners, even if they weren't at Camp LeJeune and they do not have a toxic water claim, if they find themselves stuck at a percentage they're not satisfied with, but they find themselves sort of banging their head against the wall, to reach out as well. There's no charge to have that process, to have it reviewed. And then, so we're actively getting involved in that as well. But it relates to the Camp LeJeune water, because a lot of these individuals that have been at 60 or 70% for years, that had no idea that their kidney, liver, bladder, kidney disease, or other issues were related to the water which they were exposed to while they were on active duty. They're now entitled to have that VA disability rating reviewed again. So I wouldn't lose sight of that. There's really two components. And we're reviewing every person that contacts us with the Camp LeJeune water cases. One of our first questions is, have you filed for VA disability? And if you have, what is your current rating? Because in a lot of those cases, when you add on the conditions from the toxic water, which I mentioned earlier, the VA already has a number of presumptive conditions. That can really impact the veteran's life as well and provide them with some additional benefits.
Are you talking more about like the 1151 right now, like filing for like an 1151?
Well, actually, from just the standpoint of if they have an open claim, regardless of what their rating is, and this is an aside, and I know it wasn't the topic that we were discussing. I had never, for example, filed for VA disability benefits. I don't know that I would be entitled to any. I did learn through this process that my father, who's a retired lieutenant colonel and is 86 years of age, has been at 60% since like 2012. And I know from my initial review and everything, and he sort of accepted that because that's what the government told him, which I know from your former Marine background, that's what he was entitled to. But the reality is, once I reviewed this with my partner, who deals with the VA disability claims solely day in and day out, one glance, and he indicated that he was confident he should be at 100%. And that's the only reason I referenced this, is just not to lose sight of it, that there may be, if they've never filed, they should file. And if they have filed, but they're not receiving any compensation for exposure to the toxic water, they may have an additional, avenue to pursue.
It's so crazy when I look at the list of illnesses and the diseases. I know I was there a lot later, and I'm not saying that I was exposed to some deadly toxins, but what happened to me in January of 2016 is I ended up having a bone-eating staph infection that set up shop in my spine, and it began to eat away at my bone, the disc, the spinal tissue, kidney, bladder, and it left me with permanent injuries all in my body, all on the inside of my body, from my C-spine all the way down to my feet. Now, the infectious disease doctor says that, well, you had this for 4 months because a lot of it was delayed and denied care, VA medical malpractice. Nothing, I never had an open wound sore or anything like that. It was just one day I couldn't get out of bed and I couldn't walk. And the next thing you know it, I'm stuck in a chair, and that's where I lived until I had this experimental surgery 4 months down the road that stated that, yes, indeed, my spine had been moth-eaten, and there was some sort of a staph infection that set up shop in there that ate me alive for over 4 months. Now, the infectious disease doctor says that I consumed something from who knows when to that January or 2016 moment, and he says that it attached to my spine and it lived in a dormant state, and then one day it woke up. And so, and I know my dates are wrong here, but that's just something I'm always going to have in the back of my mind to think about. Where did I pick up something so deadly and keep it within my body for such a long period of time for it to attach and to lay in a dormant state and then one day wake up? Have you seen any cases that are similar to mine?
I have, but now when you're talking about the time frame, I mean, we really unfortunately haven't encouraged people to, pursue it if they weren't there during the relevant time frame. I think what will be interesting is in 2023 when this ATS-DR report comes out dealing with vapor intrusion. So I'm absolutely confident, based on the studies and things that I've read and I've seen, that even when you were there in the 90s, that there was at French Creek, as you know, I mean, that there would have been still contaminated groundwater. It may not have been being pumped out and served to Marines and their dependents and their families, but it was seeping out of the ground from a vapor intrusion standpoint. And I've had people that I represent talk about the smell, just a general fuel smell. And of course, when you're on a Marine Corps base and you have all the diesel and the fuel and all the other things going on, but there's a study coming out. It'll be interesting to see what they find in terms of that vapor intrusion, which is that idea, like you asked earlier, about excavating the ground, which is something they would normally do at a Superfund toxic site. They have done some of that at LeJeune, sort of in the process of rebuilding housing and other things, but they have gone in and done that in some areas where they've actually excavated the soil and removed it. Mm-hmm. So I don't have any question but what there's probably still some ongoing exposure, from that vapor intrusion that's rising up out of the ground, and probably will be for years to come. Hopefully it's just at levels today where it's not as toxic, as it would have been back during the time frame.
Yeah. Typically when they'll do that, they'll set up the excavator and they will have a team of folks there that will be, Tyvek'd out, and then they'll have an air monitor to kind of pinpoint the parts per million of what's coming out of the ground. If it's contaminated, if it's not, take soil samples, everything else like that, because that's how ultimately we're going to find out what the real underlying problem is. And if it's still there, from just the soil samples and the continuous water samples. And then again, the air samples, like you were talking about, the ground, the vapors, and that's very interesting.
I'll watch it for sure
to know that. So, Mr. Ken King, this has been great, man. I
thoroughly enjoyed it.
Go ahead.
I said I thoroughly enjoyed it. Enjoyed speaking with you.
Yeah. If we can get this out to people, they may have a little bit more knowledge now on how it all began and what the history is and what the dates are and who to contact. Folks, if you need help call Ken King today. Go ahead and reach him online, kinglawfirm.com. That's kinglawfirm.com. He is in the Jacksonville, North Carolina area, and he can serve you. He's got a team of qualified attorneys that work underneath him, and they can get you guys all taken care of and hopefully get you some compensation that you deserve for the time you spent serving our country. So, Ken, with that, I sincerely appreciate everything you have done and continue to do in the military and veteran community. Your service, sacrifice, and dedication to our great nation is truly admirable, sir.
Thank you for your service as well.
Thank you. Folks, remember to stay inspired, stay encouraged, stay motivated, and always stay in the fight. Until next time, for Today with Tally, this is Brian Tally.